Hi, this is Moumita Rahman, the immigration attorney here to help you navigate the complex world of immigration. In today's video, I'm going to talk to you about some of the common reasons why your fiancé application may have been denied and some of the problems that you may have encountered along the way. It is important to know that there are two main stages of a fiancé visa application and that a denial can take place at any of these two stages. The first stage usually takes place here in the US when you file your I-129F petition with the US Citizenship and Immigration Services. The next stage, what happens after the fiancé visa petition with USCIS is approved, occurs when you have your interview at the foreign consulate of your home country in order to receive the fiancé visa stamp in your passport. This application may be denied at that stage even after USCIS has approved it. So let's talk about some of the reasons why you may have been denied at the first stage, which is the I-129F. One of the common reasons that an I-129F might be denied is because you failed to meet the basic requirement that the sponsor must be a US citizen. Another reason might be if the US citizen can't even prove that their previous marriage has been lawfully terminated. This is really important because in order to get a fiancé visa, you have to prove that you have no barriers to marriage. And obviously, if your first marriage is still not legally over with a divorce, then you can't petition for a fiancé. Another reason that the I-129F might be denied is if you cannot prove that you have met your fiancé in person at least once in the 2 years before making the application. And another reason why your fiancé visa I-129F petition might be denied is if you, as the US sponsor, have certain domestic violence convictions, or if you have made too many fiancé visa applications. So let's say everything goes well and your I-129F has been approved and you're ready for your fiancé to go to the consulate for the interview. They go to the interview, the consular officer asks many questions, but at the end, a denial is received. What are some of the common reasons why this application may have been denied by the consular officer? So let's just say that one of the most common reasons for denial might be if you, as the foreign fiancé, have committed fraud or misrepresentation for the purposes of seeking an immigration benefit. I want you to understand that when the consular officer makes a determination of fraud or misrepresentation, it is not just because you may have lied about something. It also can happen if you have omitted a certain truth. And either way, whether you lie about something or whether you omit a fact, if any of these two things prevent the consular officer from asking further questions, or if it would have possibly made a difference for them to approve your application, then it is considered fraud or misrepresentation. Another reason why the I-129F K-1 interview might be denied is because the US citizen does not make enough money and the consular officer thinks that you, as a foreign fiancé, are at risk of becoming public charge. If you saw my videos from last week where I discussed the I-134 affidavit of support, you'll know that the US citizen needs to make a minimum amount of income in order to sponsor you. Next, another reason why you might be denied by the consular officer is if you, as the fiancé, do not pass your medical exam. It is important to note that you must get a medical exam done by a doctor that is designated by the consulate. And if that doctor finds that you have certain communicable diseases such as syphilis, gonorrhea, an active tuberculosis infection, or if the doctor thinks that you're a drug addict or an alcoholic, then you may not pass. Next, another reason why you might be denied by the consular officer is if you yourself have certain criminal convictions and this disqualifies you from getting a visa. And lastly, one of the most common reasons why a fiancé visa might be denied by the consular officer is if you have been unable to get your interview done before the I-129F period expires. Again, if you have seen my previous videos, I discuss how quickly you must do this process because once the I-129F is approved by Immigration Services, there's only a period of 4 months in order to get all this done. So anyway, I hope you found this helpful. There are many reasons that an application might be denied. There's no one-size-fits-all. So remember, before you undergo this process, consult with an attorney and get guidance on your case. So if you've ever done this process and you've been worried about being denied, leave me a comment. Let me know what your experience has been. I hope you enjoyed this video, and if you found it informative, please subscribe and hit that notification bell so that you receive updates of my latest videos. I'm Moumita Rahman, the immigration attorney here to help you navigate the complex world of immigration. See you next week. This video is for informational purposes only and does not constitute legal advice. For proper legal advice on your case, please call us to set up a consultation.